Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. This week, the Hashim Thaçi defense began the presentation of its case and the calling of witnesses in the trial of Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krasniqi. On Monday, the 15th of September, James Rubin began his testimony as the first witness called by the defense. Mr. Rubin continued his testimony on Tuesday and Wednesday, during which he was questioned by the defense and cross-examined by the prosecution. The judges of the trial panel also asked the witness questions. On Wednesday, the second witness called by the Thaçi defense, Paul Williams, began his testimony, which concluded today. Hearings in the trial are scheduled for next Monday, Tuesday, and Wednesday. In the same case, on the 11th of September, the trial panel granted a request by the Thaçi defense to amend its exhibit list, adding 4 documents related to 2 witnesses. In a separate decision on the 12th of September, the trial panel granted a Thaçi defense request for the admission of several items into evidence. The trial panel also informed that some of the items requested for admission will be considered in a separate decision related to Rule 154 requests. Rule 154 allows a party to admit the written statement of a witness into evidence in place of direct examination in the courtroom. On the 16th of September, the trial panel granted a motion by the Victims' Counsel asking the court to take notice of several adjudicated facts from the Pietrashala war crimes case, which Victims' Counsel considered to be relevant to the harm caused to victims participating in the case of Mr. Thaçi, Veseli, Salimi, and Krasniqi. The annex to the decision provides details of the facts about harm suffered by victims held in the Kukës metal factory in northern Albania in 1999. For example, that all detainees in one of the rooms were physically and psychologically abused on a daily basis by several members of the KLA, forced to witness and to listen to the physical abuse of their co-detainees, and threatened with violence or death. The adjudicated facts from the Pietrashala case also include the fact that the detainees in the Kukës metal factory suffered long-lasting injuries, both physical and mental, such as head injuries, burn injuries, a broken elbow, broken teeth, persistent and severe pain throughout their bodies, feelings of shame, fear, and vulnerability, and post-traumatic stress disorder, including nightmares, flashbacks, and intrusive memories. Under the rules, the trial panel in one case may, in the interests of a fair and expeditious trial, take judicial notice of adjudicated facts from other proceedings of the specialist chambers, or from final proceedings before other Kosovo courts, or from other jurisdictions relating to matters at issue in the proceedings under consideration. And they may do so to the extent that they do not relate to the acts and conduct of the accused as charged in the indictment. In the case of Hashim Thaçi, Bashkim Smakaj, Isni Kilaj, Fadil Fazliu, and Hayreddin Kuçi, related to the alleged unlawful influencing of witnesses, the pretrial judge this week informed the parties that she intends to transmit the case to a trial panel in the first half of November 2025, subject to pending Court of Appeals panel decisions. The judge also invited the defense teams to file any pretrial briefs by the 20th of October 2025. In an earlier decision, the prosecution was given the deadline of 19th September to file its pretrial brief and its witness list. In the same case, on 15th September, the pretrial judge granted a request by the Thaçi defense to disclose to the trial panel in the Thaçi et al. War crimes case all witnesses that are testifying in both cases. This is to assist the Thaçi defense in preparing a request for certain amendments to its contact protocol with witnesses, in order to facilitate defense investigations. The pretrial judge noted that the prosecution did not oppose the request and that sharing the information would not require lifting any protective measures for witnesses. On the 12th of September, the pretrial judge granted a request to authorize the copying of the forensic image and corresponding report of the mobile telephone seized from Hayreddin Kouchi in March 2024 in order to provide the copy to the defense for Mr. Kouchi.